Now, some of the students who have been going for oral examination have been asked about the Nairobi Convention on the removal of wrecks. So I thought I'll make this video today on the convention and what IMO has to say about this convention. So this convention defines wrecks following upon a maritime casualty as a sunken or a stranded ship or any part of a sunken or a stranded ship, including any object that is or has been on board such a ship, or any object that is lost at sea from a ship and that is stranded, sunken, or adrift at sea. So examples could be, of course, lifeboats, life rafts, a mast which has been broken, any structural like a hatch cover blown off or something like that. A ship that is about or may reasonably be expected to sink or to strand, where effective measures to assist the ship or any property in danger are not already being taken, is also considered to be a wreck. So for any ship that is not being assisted by a salvage operator or something like that. Articles in the convention cover reporting and locating ships and wrecks, covering the reporting of casualties to the nearest coastal state, warnings to mariners and coastal states about the wreck, and action by the coastal state to locate the ship or wreck. It also includes criteria for determining the hazard posed by wrecks, including depth of water above the wreck, proximity of shipping routes, traffic density and frequency, type of traffic and vulnerability of port facilities, environmental criteria such as damage likely to result from the release into the marine environment of cargo or oil are also included. Measures to facilitate the removal of wrecks, including rights and obligations to remove hazardous ships and wrecks, which set out when the ship owner is responsible for removing the wreck and when a state may intervene. Liability of the owner for the cost of locating, marking, and removing ships and wrecks. The registered ship owner is required to maintain compulsory insurance or other financial security to cover liability under the convention, as well as settlement of disputes. So an example of a dispute that can occur is if two ships belonging to different companies collide and a wreck results, there could be a dispute between the two companies as to whose fault was it because of which the accident resulted, and whose responsibility will it be to then remove or address the wreck which has resulted due to the accident. This convention was adopted on 18th of May 2007, but it took about 8 years for it to come into force, and it came into force 4 years back on 14th of April 2015. The Nairobi International Convention on the Removal of Wrecks 2007 was adopted by an international conference held in Kenya, where Nairobi is, in 2007. The convention provides the legal basis for states to remove or have removed shipwrecks that may have the potential to affect adversely the safety of lives, goods and property at sea, as well as the marine environment. The convention provides a set of uniform international rules aimed at ensuring the prompt and effective removal of wrecks located beyond the territorial sea. So of course it goes without saying that if an accident or an incident has resulted in a wreck, then it is the obligation and duty of the owners to remove the wreck from the site, because then it poses a danger to the navigation for surrounding ships. The convention also includes an optional clause enabling states parties to apply certain provisions to their territory, including their territorial sea. Now, although over the period of years, the incidence of marine casualties has comparatively decreased, many thanks to the work of IMO and the persistent efforts of governments and industry to enhance safety in shipping operations, the number of abandoned wrecks, estimated at almost 1,300 worldwide, has reportedly increased, and as a result, the problems they cause to coastal states and shipping in general have, if anything, become more acute. These problems are threefold. Firstly, depending on its location, a wreck may constitute a hazard to navigation, potentially endangering other vessels and their crews, something that I mentioned before. Secondly, depending on the nature of the cargo, is the potential for a wreck to cause substantial damage to the marine and coastal environments. Now, this is particularly so if the cargo being carried is tons and tons of crude oil or oil. Thirdly, in an age where goods and services are becoming increasingly expensive, is the issue of the costs involving the marking and removal of hazardous wrecks. The Convention attempts to resolve all of these as well as other related issues. The Convention provides a sound legal basis for coastal states to remove or have removed from their coastlines wrecks which pose a hazard to the safety of navigation or to the marine and coastal environments or both. The treaty also covers any prevention, mitigation, or elimination of hazards created by any object lost at sea from a ship, for example, lost containers. The Convention makes ship owners financially liable and requires them to take out insurance or provides other financial security to cover the cost of wreck removal. It also provides states with a right of direct action against insurers. So if the insurers do not support the ship owners, do not cover for the cost, the ship owners have been paying a premium, a really high premium for the insurers to cover them in such incidents. So if the insurers do not do so, then the states have the legal right to even take action against such marine insurance companies.